Welcome to Day and Night News Prime Debate. The criminal justice system in India has faced serious criticism in recent times. It has been observed that the system has failed to protect the legal rights of the poor, Dalits, minorities and other vulnerable sections of society. The need for reforms in the present system has been felt for a long time now. But how should this be done? That's what we try to find out in Prime Debate tonight. The failure to provide equal protection of the law and safeguard the rights of the minorities has been a major issue plaguing the entire criminal justice system. Judicial reluctance and administrative indifference on one hand and growing rate of crime on the other has led to a situation where the poor find themselves brutalized and isolated.
Justice to common men is the primary objective of the legal mechanism of the country. But in the present situation, the common men have no hope of getting justice. In the judicial mechanism, there are three players, that is judge, lawyers and the common men, among which the common men are at the receiving end everywhere. The unspoken law of delays in Indian courts is the main roadblock in the way of distributive justice. It is a sorry state of affairs that none is bothered about the merit of the case. Everything goes in a motion without slightest of interest in delivering justice. Also, it is an unsaid but mostly felt reality that corruption has become all-purposive in the present system of judiciary. It is a fact that rich and powerful almost never get convicted. It's very unfortunate that for all practical purposes, there is no place for common men in the existing system. Even the Supreme Court recently lamented that the criminal justice system was not working properly in our country. The court also spoke of political interference in several cases, hampering investigations. These observations definitely highlight the lacunae in the prevalent system. It's high time that reforms are initiated so as the common man doesn't get deprived of justice.
To discuss the criminal justice system, we have in our studios J.R. Singla, retired District and Sessions Judge, Sukhdev Singh, District Attorney, Jalandhar, Ms. Ambika Gupta, Assistant District Attorney, Pathankot, B.S. Thind, former Additional Director General Police, Law and Order, Himachal Pradesh, and Mr. B.K. Srivastav, Director General, Mahatma Gandhi Institute of Public Administration, Punjab. Welcome to the studio, gentlemen.
Thanks.
Mr. Singla, I would like to start with you. The criminal justice system is very old and some efforts have been made to change it, reform it, bring about amendments. One of these was made in 1973. But perhaps it is generally felt that not enough has been done. How serious do you think is the need for reforms in the criminal justice system?
Mr. Our system is based on English system because the laws were at that time enacted by the Britishers who were our rulers. The basis on which they have enacted these laws is Irish laws because they first enacted those laws.
Singla sahab British nu gaya mein to hun 63 saal ho gaye na hun changes hoiyan us to baad ke nahi hoiyan.
Us to baad they have made some efforts to do it. They have constituted several committees to go into the details. Justice Malamath committee report was there. Justice Ribeiro committee report was there. But the thing is, these reports are there. But no further action has been taken which could materialize the reform.
Why do you think further action should not be taken?
They should take, but the question is who are to do it? Those persons.
The political will lacking sigi ya ki problem sigi?
Definitely, there is lacking.
What did Malamath committee said which has not been done and what it mandated to be done?
Malamath committee, Justice Malamath committee has suggested so many things. All the investigation, prosecution, the other related matters, all they have examined in detail. They have submitted a very long report. This long report was further examined by two committees constituted by the Ministry of Law. But the things remain as they are.
Like but as districts and session judge, now you have a wide experience. Tell us, in your opinion, what is the most pressing, change that is required?
The pressing thing which is required is with regard to investigation. Supposing a case is registered today, it is not investigated for a long period. For instance, a case has been registered today. If the IO is there, he will, whenever we go to the IO to ask, supposing the complaint victim goes to him, what happened to my case? Sir, I was busy in VIP duty. Because the police has different roles to play. Not only investigator, they are law and order authority also. So the pressing need is that there should be separate prosecuting, this investigative agency than the law and order.
So ਤੁਹਾਡੇ ਸਾਹਮਣੇ ਸਭ ਤੋਂ ਜ਼ਿਆਦਾ ਜਿਹੜੀ pressing requirement ਹੈ ਉਹ ਹੈਗੀ ਆ separation of the law and order and the investigation agency.
That is.
ਸੁਖਦੇਵ ਜੀ ਤੁਸੀਂ as district attorney ਤੁਸੀਂ ਕੀ feel ਕਰਦੇ ਜੀ ਸਭ ਤੋਂ ਜ਼ਿਆਦਾ pressing requirement ਇਸ ਵੇਲੇ ਕਿਹੜੀ ਹੈਗੀ ਹੈ?
During investigating agency, they should be separate from the law and order agency, because ਜਿਹੜੇ investigators ਹੈਗੇ ਆ, they are not fully aware with their job. They are not particularly trained in a particular special acts.
ਜੀ.
So the investigators.
ਔਰ ਕਈ ਰੋਲ ਹੈ ਉਹਨਾਂ ਦੇ, ਜਿਵੇਂ ਕਿ VIP ਡਿਊਟੀ ਵੀ ਉਹ ਕਰਦੇ ਆ, ਕੇਸ ਵੀ ਉਹਨਾਂ ਨੇ ਫੋਲੋ ਅਪ ਕਰਨਾ ਵਾ ਜਾਂ ਉਹਨੂੰ ਇਨਵੈਸਟੀਗੇਟ ਵੀ ਉਹਨਾਂ ਕਰਨਾ ਵਾ, ਉਸ ਤੋਂ ਬਾਅਦ ਉਹਨੂੰ ਪ੍ਰੋਡਿਊਸ ਵੀ
ਇਹੀ ਅਸੀਂ ਸਾਰੀ ਚੀਜ਼ਾਂ ਲੈਕ ਕਰ ਰਹੇ ਹੈਗੇ ਮਤਲਬ ਇਨਵੈਸਟੀਗੇਟਰ ਮਤਲਬ ਆਪਣੇ ਕੇਸ ਜਦੋਂ ਮਤਲਬ ਰਜਿਸਟਰਡ ਕਰਦੇ ਹੈਗੇ ਮਤਲਬ ਉਹਨਾਂ ਨੂੰ ਡਿਊਟੀਜ਼ ਹੋਣ ਕਰਕੇ ਮਤਲਬ ਵੈਲ ਇਨ ਟਾਈਮ ਇਨਵੈਸਟੀਗੇਸ਼ਨ ਕੰਪਲੀਟ ਨਹੀਂ ਹੁੰਦੀ ਹੈਗੀ, ਬਾਰ-ਬਾਰ ਮਤਲਬ ਕਈ ਵਾਰੀ ਮਤਲਬ ਆਪਣੇ ਚਲਾਨ ਪ੍ਰੋਪਰ ਟਾਈਮ ਤੇ ਕੋਰਟ 'ਚ ਪ੍ਰੈਜ਼ੈਂਟ ਨਹੀਂ ਹੁੰਦਾ, ਇਸ ਦਾ ਬੈਨੀਫਿਟ ਕਈ ਵਾਰੀ ਅਕਿਊਜ਼ ਨੂੰ ਮਿਲ ਜਾਂਦਾ ਹੈਗਾ।
ਯੈਸ ਮਿਸਟਰ ਸ੍ਰੀਵਾਸਤਵ।
There is a separate force for security duties, such as the CRPF or the police battalions and PAP. But you cannot distinguish so readily the law and order and the crime cognizance. Law and order means security and policing. Supposing I am going on patrolling and something wrong is happening, so the person on patrolling knows what kind of wrongs are taking place and who are doing and who are the prompters and who are the abettors. Now if you separate them from the investigator, supposing immoral trafficking is going on, gambling is going on, and many narcotics things are going on, who will investigate? The person who is on patrolling. See, the patrolling policing duty, it is if some rioting has taken place, some other things have taken place, the people on duty, they know who has done it and how to investigate it.
So you also feel that there is need for separation?
No, it is not easily possible to separate it.
So the following, let's say there is a force of 1,000 people, the following 500 are responsible for law and order, and the
law and order,
following 200 are only for investigation of
law
crimes.
And order includes policing and patrolling.
Ms. Gupta, like to ask you, in your opinion, what is the most pressing requirement at this point of time, in the criminal justice system for reforms?
Important problem which the criminal justice system is facing is the delay in the judicial verdict as well as the delay in the investigation. So first of all, let us come to the delay in the judicial verdicts. Let us start from the very roots. First of all, an offence is committed and the person who is the informant, or let's say the complainant, he informs about the commission of the offence to the investigating agency, or let's say police. The person has to run from pillar to post to get the FIR registered. This is the state of affairs in the Indian system. Sir, if this problem is dealt with effectiveness by the police,
so I think the registration of the FIR is a major problem in your opinion.
First, this is the first problem.
Right.
Secondly, the problem comes where the investigation comes to play. Sir, the investigators, they should be given a limited time frame in which they have to investigate the entire case and have to report.
I think two very valid points. One, delay in registration of the FIR. The second is delay in the investigation of the case.
And I have a third point also. Yes. That is the preparation of the challan. After the completion of investigation, the challan is to be presented in the court under section 173 of the CRPC.
Yes. Are the police people trained to prepare a challan?
Not at all. They should be, the investigating officers should be the law graduates, in my opinion, if possible. Secondly, even the higher officers of the police, they should be law graduates. And sir, a person who has even a single citizen, if a girl, if she is a law graduate, she will have a different opinion and different.
Well, Ms. Gupta, we possibly can't have all citizens as law graduates.
No, I don't say that. I don't say that.
You raised some very valid point. Before we forget, I'll just come back to you. So, Vedi, I'll just come back to you. Mr. Thin, now 2-3 points that Ms. Gupta raised relate to the police. एक तो जो FIR नहीं रजिस्टर करते पुलिस ਦੇ ਵਿੱਚ ਇਹ ਹਿਮਾਚਲ ਚ ਵੀ ਇਹੋ ਹੀ ਟ੍ਰੈਂਡ ਹੈ ਪੰਜਾਬ ਦੇ ਵਿੱਚ ਤੇ ਔਰ ਹਰਿਆਣਾ ਚ ਤੇ ਨੋਟਿਸ ਹੋ ਰਿਹਾ ਹੈ
ਨਹੀਂ ਹੁਣ ਪਹਿਲਾਂ ਹੁੰਦਾ ਸੀ ਜੀ ਇਹ ਟ੍ਰੈਂਡ ਨਾਓ ਆਈ ਥਿੰਕ ਵਿਦ ਅ ਲੋਟ ਆਫ sort of media gaze and scrutiny I think in say I can say safely that in 90% of the cases there is no delay in registration of the case.
From the Center for Law and Justice, which is a part of the Mahatma Gandhi Institute in Chandigarh, which Mr. Srivastava heads, कि जे एक nodal officer बनाता जावे, वो nodal officer जेड़ा he could be sitting in the Suvidha Center, he could be a part of the district magistrate office, he could be a part of the courts, the district courts. And if somebody, a police officer doesn't register an FIR, the complainant can go to the nodal officer and nodal officer will ensure that the FIR is registered. Do you think it's a good idea?
No, I don't think it's a good idea, because I feel that responsibility divided is responsibility destroyed. You should take the district SP and the DIG range into task if they cannot control the police, because investigation of crime and prevention of crime is the primary duty of the police. And when we have induction at a level of IPS officers at the higher level, it should be their duty to, and there are enough safeguards in the police rules. There are enough safeguards.
Well, I'm not sure many of us agree there are enough safeguards, but I'll come back to you a little later. Just 1 minute. I'll just come back to you. I want to take Mr. Srivastava into the discussion. Mr. Thind feels कि ये बहुत चंगा आइडिया नहीं हैगा कि नोडल ऑफिसर बनाना होवे. ਤੁਸੀਂ ਡਿਸਟ੍ਰਿਕਟ ਚ ਹੀ ਰਹੇ ਜੇ, ਤੁਸੀਂ ਕਮਿਸ਼ਨਰ ਹੀ ਰਹੇ ਜੇ. ਵਾਟ ਇਜ਼ ਯੂਰ ਐਕਸਪੀਰੀਅੰਸ?
No, ਇੱਕ ਥਰਡ ਪਾਰਟੀ ਨੋਡਲ ਆਫਿਸਰ ਬਣਾਉਣ ਦੇ ਵਿੱਚ ਕੋਈ ਹਰਜ ਨਹੀਂ ਹੈ, ਬਿਕਾਜ਼ ਉਹਦੇ ਵਿੱਚ ਐਟਲੀਸਟ, ਬਿਕਾਜ਼ ਫॉर ਐਗਜ਼ਾਮਪਲ ਇਹ RTI ਐਕਟ ਹੈ ਜਾਂ ਦੂਜੇ ਤੀਜੇ ਨੇ, ਉਹਦੇ ਵਿੱਚ ਜਾਂ ਟੋਲ ਫ੍ਰੀ ਟੈਲੀਫੋਨ ਨੰਬਰ ਹੁੰਦਾ ਹੈ, ਕੰਪਲੇਂਟ ਸੈਂਟਰ ਹੁੰਦਾ ਹੈ. ਇੱਕ ਥਰਡ ਬਣ ਜਾਣ ਦੇ ਨਾਲ ਐਟਲੀਸਟ देयर वुड बी एन अल्टरनेटिव एंड दैट विल एक्ट as a force to prevent this.
So you think it's not a bad idea to have a nodal officer? Ms. Gupta, you were raising another point. Yes, so we are going to a break, so quickly you will have to wind up in half a minute.
Objections which have been taken by the concerned APP, they should be complied with by the police, and thereafter the challan is to be presented in the court. Once the challan is presented, the investigating officer should assure that all the witnesses are present in the court whenever required, whenever summoned, and after that the summoning agency comes into play. Sir, here they give when the judge issues summons and they give fake reports upon that. Oh, kar nahi milya banda, oh bahar gaya hai, like that. These reports should be checked. Strict disciplinary action should
Checked
be taken.
by who? What is your suggestion?
By the concerned senior police officers. Sir, they should take disciplinary actions, turn disciplinary
So
action.
मतलब है कि जो summon issue होंगे हैं, they should be properly served. And जो नहीं serve होंगे, उधर जो कोई
They are
बेईमानी कर
not
रहा है,
being
तो they should
served
be
properly.
punished.
This is the main problem which we are facing. That is why the cases are being closed by order by the concerned court.
So serving of
These courts
summons.
do not apply do not exhaust other methods. They just close the case by order.
Right. So serving
This
of
is the
summons is a
problem.
major issue. Sukhdev ji, I'll just come back to you. We are discussing the criminal justice system. Mr. Singla, the Mahatma Gandhi Institute has organized a training of the public prosecutors. It training ਦੀ ਜ਼ਰੂਰਤ ਕਿਉਂ ਪਈ?
Sir, the Criminal Procedure Code was amended in 1973.
ਜੀ.
ਉਸ ਤੋਂ ਬਾਅਦ ਹੁਣ ਤੱਕ ਕੋਈ ਸਟਰਕਚਰਲ ਟ੍ਰੇਨਿੰਗ ਪਬਲਿਕ ਪ੍ਰੋਸੀਕਿਊਟਰ ਵਾਸਤੇ ਨਹੀਂ ਦਿੱਤੀ ਗਈ. ਇਹਨਾਂ ਨੂੰ ਜਿਹੜਾ ਡੋਮੇਨ ਹੈ ਉਹ ਕਿਸ ਤਰ੍ਹਾਂ ਇਹਨਾਂ ਨੇ ਆਪਣੀ ਡਿਊਟੀਜ਼ ਨੂੰ ਨਿਭਾਉਣਾ ਹੈ, ਹਾਊ ਆਰ ਦੇਅਰ ਟੂ ਪ੍ਰੂਵ ਦੀ ਕੇਸ ਇਨ ਦੀ ਕੋਰਟ, ਇਹ ਇਹਨਾਂ ਨੂੰ ਦੱਸਿਆ ਨਹੀਂ ਸੀ ਗਿਆ. ਅਸੀਂ ਇੱਕ ਸਟਰਕਚਰਡ ਪ੍ਰੋਗਰਾਮ ਤਿਆਰ ਕੀਤਾ ਹੈ. ਉਹਦੇ ਮੁਤਾਬਕ ਇਹਨਾਂ ਨੂੰ ਅਸੀਂ ਸਾਰੀ ਜਿਹੜੇ ਡੋਮੇਨ ਡਿਊਟੀਜ਼, forensic science, forensic medicine, handwriting expert, we also take them to CFSL, because the modern technology, they must know how the DNA tests are to be made, how this brain mapping is to be done. All these things they will know.
ये सारी ट्रेनिंग ਜਿਹੜੀ ਹੈ ਚੰਡੀਗੜ੍ਹ ਬਹਿ ਕੇ ਹੋਊਗੀ ਜਾਂ ਤੁਸੀਂ ਬਾਹਰ ਡਿਸਟ੍ਰਿਕਟਸ ਦੇ ਵਿੱਚ ਵੀ ਜਾਓਗੇ?
Sir, we have organized, we have got 5 years plan.
अच्छा.
During the first year we are doing this at the headquarters, and the subsequent years we will frame the new models of training. That can include even training at the districts.
Mr. Srivastava, I want to come back to you. You know, now the investigation of the police is obviously the head of that force is the DGP, that comes under the DGP, and the public prosecutors come under the director prosecution. Now, they're two separate